picture this.
Yeah.
Someone needs a crucial document notarized, but their wallet's gone missing, no ID anywhere. What happens then? Like, what do you actually do?
Yeah, that's a tough spot. And it's exactly the kind of knotty situation we're untangling today. We're going to dive deep into a really critical part of Georgia notary law, the role of credible witnesses.
Right.
Yeah.
Hey, my notary buddies, future LaDarrell here. I am so sorry to interrupt this podcast, but I need to bring you an important update. As of 2025 in the state of Georgia, we can no longer use a credible witness. I know, it's insane. This cuts out an extreme amount of individuals that we can no longer serve. Think about our elderly community. Think about the individuals who are under the age of 17 or 18 that does not have a state ID or a driver's license yet. Think about those individuals who are unfortunately homeless that cannot get an ID in a timely manner to get their documents notarized. This presents a huge problem, but you know what? This was voted on without any of us as notaries who are in the trenches doing things, but I did have to bring this update to you to let you know that we can no longer do the credible witness, but you probably should still listen to this podcast because it was a damn good one that I recorded back in the day. I'll talk to y'all later in the future. Bye.
Because they're essential for making sure those signatures are legit when ID isn't an option.
Exactly.
We recently tuned into this really interesting discussion, within the Georgia notary community about this exact thing. And it just highlighted how vital it is to, really get these specific rules down.
For sure.
So our mission today is pretty straightforward. We want to give you, our listeners, a clear and practical understanding of how credible witnesses actually work in Georgia notarizations.
So you feel informed, ready if you ever run into this?
Exactly. And just so you know, this info comes straight from, someone deeply experienced in the Georgia notary world. Okay, so let's unpack this. Why does Georgia even have this system? Credible witnesses, I mean. What problem are they trying to solve?
Well, at its core, it's really about verifying who someone is when they don't have that standard photo ID.
Yeah.
Georgia law, like laws in many states, recognizes that sometimes people just don't have their driver's license or passport handy, and maybe they can't reasonably, get one right at that moment.
Right, practical reasons.
But, and this is key, the need to be sure about the signer's identity. That stays absolutely crucial for the whole notarization to be valid.
Makes sense.
And it's definitely worth remembering, notary laws really vary state by state. So what works in Georgia might be totally different somewhere else.
Good point. Always check local rules.
Yeah.
Okay, so Georgia has specific guidelines for these situations. What are the main ways this plays out? When do credible witnesses actually come into the picture?
Right. So in Georgia, there are basically two main scenarios where you can use credible witnesses.
Okay.
The first one involves just one credible witness. Now, this is allowed if, and these are important ifs, the notary personally knows that witness.
Personally knows them, okay.
And that same witness personally knows the person who's signing the document.
So it's like a chain of personal knowledge.
Mm-hmm.
Notary knows witness, witness knows signer.
Exactly. It's built on, existing familiarity at both levels.
Okay, that sounds like a pretty solid safeguard relying on those established relationships. What's the other scenario?
The second way is when the notary doesn't personally know the witness, or witnesses, I should say.
Okay. So no prior connection there for the notary.
Right. In that situation, Georgia law bumps it up. You need two credible witnesses.
Two people. Got it.
Yeah. And here's a really critical part. Both of these witnesses have to personally know the signer.
Okay, both know the signer. Makes sense.
And maybe even more importantly, neither of those witnesses can be related to the signer at all. And they also can't have any kind of financial stake, an interest in the document being notarized.
Oh, that's huge. The conflict of interest thing.
Absolutely huge. It's all about preventing situations where someone might be, biased or unduly influenced. You don't want someone vouching for identity if they stand to gain something from the document.
Yeah, you can see how that could go wrong fast, especially if the notary doesn't know them from Adam.
Exactly. I mean, history shows that, unfortunately, sometimes family or people with a stake might be tempted to overlook things or even participate in something shady. These rules are safeguards.
Really important safeguards. Okay, so let's say you have your witness or your two witnesses lined up. What's the actual process? Does the notary just, take their word for it?
Oh, no, definitely not. The procedure itself is really specific and vital. The Georgia Notary Handbook, I think it's the 13th edition, page 59, it actually provides a sample form for this.
Wow, okay, so it's formally documented.
Very formally. It shows how seriously the state takes getting this right. But honestly, even more critical than the form, it's administering a very specific oath to the credible witness or witnesses.
An oath. Okay, not just any oath.
No, not just a generic, do you swear to tell the truth kind of thing. It's specifically worded. It confirms they know the signer. It attests that the signer genuinely can't reasonably get valid ID right then. and it makes them state under oath that they themselves have zero personal stake in the transaction.
Okay, so it nails down all those key points we just talked about.
Mhm.
Their knowledge, the ID issue, their impartiality.
Precisely. These oaths, they're not just, formalities or box ticking. They are actual legal protections built right into the whole process.
That really does underscore the gravity of it. It's a serious declaration they're making.
Mhm.
What else? Anything else a notary needs to absolutely keep in mind here?
Yes, another really crucial point. The credible witness or witnesses must be physically present for the entire notarization.
The whole thing, start to finish.
The whole thing. They can't just pop in, sign something, and leave.
Why is that so important?
Well, their continuous presence means they can vouch for the whole transaction, not just the identity part. They're there to see that the signer appeared willingly, seemed to understand what they were signing, the whole context.
Okay, so they're attesting to more than just, yeah, that's Bob. They're witnessing the act itself.
Exactly. They're putting their credibility on the line for the integrity of the entire signing event.
That makes perfect sense. Now, something interesting came up in that discussion we mentioned about best practices. Even when the law allows credible witnesses, some experienced notaries, well, they have their own preferences, right?
Yeah, that was a fascinating point. What you see is even though the legal framework in Georgia is clear about allowing credible witnesses under these rules, a really seasoned notary might still sort of prefer to see traditional photo ID from everyone involved, even people they actually know personally.
Really? Even if they know them?
Why? Well, it's not usually about, a lack of trust in that person they know. It's more about adding an extra layer of security, just minimizing any potential future risk or challenge to their notary commission.
Like belt and suspenders, covering all bases.
Kind of, yeah. Recording ID, even when you know the person, can just be a proactive step. It helps prevent any possible complications or questions down the road. It's sort of a better safe than sorry approach in a job where accuracy and, legality are absolutely paramount.
Okay, that makes a lot of sense. It's about protecting yourself and the integrity of the notarization long term. So credible witnesses are a valid tool under Georgia law, but seeing standard ID is maybe the gold standard if possible.
You could put it that way, yeah. Is the extra layer.
Now, thinking about the real world,
Yeah.
are there times when, even if you could use credible witnesses according to the rules, a notary should still say no, should decline the notarization?
Oh, absolutely. Definitely. There are several red flags that should always make a notary pause, maybe even refuse the signing, regardless of whether credible witnesses are theoretically available.
Like what?
Well, the obvious ones are if the signer themselves has, say, an expired ID or no ID, and they don't meet the specific criteria for using credible witnesses in that exact moment, that's a clear stop.
Right, if the basic conditions aren't met.
But beyond that, and this is really important, any sign that the signer might be under duress or being coerced, or maybe they just seem really confused about the document they're signing, those are huge red flags.
Especially, I imagine, in situations like elder care.
Exactly. Elder care situations are prime examples where you need to be extra vigilant. If a notary gets any kind of gut feeling that the signer is being rushed or manipulated, or maybe they just don't fully grasp what's happening, it's honestly their ethical duty, their professional responsibility to refuse that notarization.
So trusting your judgment is key. It's not just robotic verification.
Absolutely crucial. That gut feeling is often right in these scenarios.
Okay, that really drives home that the notary's role is, well, broader than just checking boxes. Ensuring willingness, understanding. That's big.
Yeah.
Now, let's shift gears just a little. That discussion we looked at also touched on something else, the value of notaries connecting with other professionals. Why is that seen as a smart move?
Yeah, connecting this to the sort of business side or the professional ecosystem, building strong relationships with attorneys can be incredibly valuable for a notary.
Which kinds of attorneys?
Especially those who specialize in areas like family law and, again, elder care law. Think about it. These lawyers constantly deal with documents needing notarization.
Right, wills, trusts.
Exactly. Estate planning is a huge one. Powers of attorney, wills, trusts. These involve significant assets, sometimes complex family dynamics, and they absolutely require legally sound notarization.
Makes sense.
So if a notary proactively reaches out, markets their services directly to these attorneys, they can become that go-to, reliable resource for the attorney's clients.
Instead of just waiting for individual people to find them randomly.
Precisely. It can be a much more targeted, much more efficient way to build a practice. You're tapping into a steady stream of need. The discussion also mentioned personal injury attorneys as another potential connection point. They often need affidavits and other legal documents notarized too.
So it's about building those strategic B2B relationships within the legal field, less reliance on just direct-to-consumer marketing.
You got it. It can be a smarter way to build a sustainable notary practice.
And speaking of the business side, for notaries looking to, make a real go of it financially, the discussion also briefly touched on pricing and revenue. How do experienced folks approach that? Is it just a flat fee per stamp?
Yeah, that's an important point for anyone treating this as a serious business. Experienced notaries often move beyond just a simple per-signature fee. They develop more strategic pricing.
Also,
Well, especially for more complex signings, maybe things that are time-sensitive, like power of attorney documents needed urgently at a hospital or something. The pricing might reflect that complexity and urgency.
okay.
They also understand how to properly charge for things like, say, witness fees if they're arranging the witnesses, not just using the signer's own, and potentially offering additional related services.
Like what kind of services?
Maybe things like travel fees, printing costs if documents are extensive, or even facilitating the filing of certain documents at the courthouse afterwards, if that's something they offer. It adds value to the appointment.
Right, so it's about looking at the whole service provided, not just the single act of notarizing. Yeah. Working smarter.
Exactly. It's about understanding the full value you bring and structuring your fees and services accordingly to, meet your business goals.
Okay, that provides some good context on the business end. So let's try and pull all this together. If we boil it down, what are the absolute must-remember points about using credible witnesses here in Georgia?
Okay, yeah, let's summarize. Key takeaways. First, Georgia law has specific, distinct rules for using credible witnesses when standard photo ID is out of the picture. Don't assume it's like other states.
Right, Georgia rules.
Second, remember those two main scenarios. One witness works if the notary knows the witness and the witness knows the signer. Two witnesses are needed if the notary doesn't know them, and both must know the signer and have absolutely no relation or financial stake.
Got it. One or two, depending on who knows who, and zero conflicts of interest for the two-witness rule.
Precisely. Third, following the proper procedure is non-negotiable. That means using the right documentation, administering that very specific oath from the handbook,
The specific.
and making sure those credible